breaking news out of Hawaii brought to us by the great Second Amendment attorney out there on the left coast, Alan Beck. He has brought to America's attention this insanity going on with the Honolulu Police Department in terms of not allowing people essentially to be able to buy a gun or get a concealed carry permit because conveniently, at least according to Attorney Beck and the reporting going on out on the West Coast, specifically Hawaii, it turns out that the conditions that one needs to satisfy in order to get either a purchase permit or a carry permit are impossible to satisfy right now because of the conduct or lack thereof of the city of Honolulu. Stay tuned. We're going to break this down real quick when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and a nominee for two separate categories of the Gundy Awards for 2024. Top Male Influencer in the Second Amendment space and Top Voice of the Second Amendment. I am proud and honored to be nominated in both categories for the 2024 Gundys. All right, folks, we're going to make this quick. In Honolulu, Hawaii, according to the reporting and various quotes in the press by the great Second Amendment attorney out there in California and Hawaii in the Ninth Circuit, Alan Beck, it turns out that Honolulu has passed a new law that makes it harder to get a purchase permit, or an acquisition permit, if you will, to acquire a firearm, as well as has made it harder to get a concealed carry permit. Now, without getting into all the details, what's shocking about the situation, and clearly unconstitutional under NYSRPA versus Bruen, and the lack of historical analogs that could possibly justify what Honolulu is reported to be doing, it turns out in order to get either a concealed carry permit or a purchase permit to acquire a handgun, firearm, you need to get some sort of a proof of certification that you received training from a certified firearms instructor. That's a whole separate issue we can get to at a different time. Turns out that, according to the reporting coming out of Hawaii, that the Honolulu Police Department has not signed off and approved, for the moment under the new rules, any verified firearms instructor, which means if you apply for a purchase permit or a carry permit after, I believe, December 18, 2023, you're not able to get that permit because the new rules that implicate who constitutes a certified firearms instructor are no longer valid until next year sometime at some unspecified date, which means that all those people are really being held in limbo if you are trying to get a permit to carry or to purchase a firearm right now in Hawaii, specifically in Honolulu and some related cities. Now, this is clearly unconstitutional because if you go back to the founding, 1791, when the Second Amendment was adopted, there is simply no historical analog law that could conceivably justify forcing people to wait long periods of time before they get a permit. In fact, there weren't even really permits at the time. And there certainly were no training requirements outside of, again, conceptually, training requirements if you were a member of the militia. But those don't count because that was part of your militia training, having nothing to do with simply owning a firearm for your own private uses on your farm or in the city or wherever it is. So any historical analogs associated with his military training or militia training, not analogous to, because again, those only dealt with militia training, had nothing to do with simply owning a firearm in your private capacity. So it's pretty clear that Honolulu and the state of Hawaii, with their new rules, is violating the Second Amendment. Now, will there be enough time to bring a lawsuit and get a remedy? I don't know. But I will say this, that if you look at the Bruen decision, you look at what Justice Brett Kavanaugh and Justice John Roberts said, they made it very clear that if you're going to have a shall issue permitting regime, right, you can have permitless carry, or you can have a shall issue permanent regime, but that shall issue permanent regime clearly has to be objective criteria. If you recall the Rahimi case, during oral argument, the Solicitor General of the United States for Joe Biden's anti-gun Department of Justice specifically said that executive officers, which is all police officers and anyone that works for the governor's office, for example, or the president, they do not have constitutional authority under any set of circumstances to engage in the discretion associated with deciding who can and cannot have firearms. So even the Biden administration, before the United States Supreme Court and Rahimi, said that what Hawaii is trying to do here is unconstitutional. because Hawaii is basically trying to get all this information, and it looks very discretionary. But of course, the reality is what Attorney Beck has pointed out is the discretion doesn't even play a role right now, because it's simply impossible if you apply for a permit or a carry permit today in Honolulu or in several other related cities apparently, you are not able to get the certification you need to complete your application until some future date when they've identified who these firearms trainers can be. Okay? Now, what's shocking about this is there's simply, not only is there no historical analog for requiring this kind of training or for certification of these firearms trainers, there's certainly no justification for these delays. So here is what I want to flag for you, as I've said before. And I think that as we see more and more of these blue state jurisdictions doing stupid things and clearly unconstitutional things, which apparently is going on in Hawaii with Honolulu and other cities right now, according to the reporting coming out of there, is that the way this should work is that people should, if you're in a shall-issued permitting regime, people should be able to submit their application. And as soon as that application is submitted, you are entitled to carry a firearm. You are entitled to purchase a firearm. Period, full stop. Now, if it turns out, as the government processes your shall-issue permit, your permit, and turns out they conclude that you are somehow ineligible as a prohibited person, let's say under 18 U.S.C. 922G, one of those categories there, they conclude that you're not eligible to have a firearm or to carry a firearm. Well, then it's the burden is on the government to come to you and say you can no longer carry because we've concluded that you're a prohibited person, for example, and we, being the government, bear the burden to establish this is the case. If they want to litigate and sue you over this or you want to consent, that's fine. But the bottom line is that the presumption is you should be allowed to carry because the system that I'm describing, where as soon as you apply, you get to carry, creates a proper incentive system for the government to follow the Constitution. Because right now, the way it's working is that Honolulu and the state of Hawaii, for example, have said that police departments have 40 days before they have to act on a permit request. Now, that's simply too long. You would never get away with this if you needed 40 days to get a parade permit or a First Amendment permit or 40 days before you could file a lawsuit seeking redress against the government for some reason. And yet that is the case out in Hawaii. So it seems to me eventually the system has to move to you're automatically allowed to carry and the burden shifts to the government at some point. If they want to come try to say you can't, then let them give it a shot. But at least the incentives will be for the government to move with speed, because if they think someone is not allowed to carry a gun, it will incentivize them to move with speed to take that right away from you because you're not allowed for some technical reason or whatever it is they're going to argue. But right now the incentive is one-way ratchet in favor of delay. So every one of these district attorneys, every one of these police departments, every one of these licensing divisions, every one of these governors in these terrible anti-gun blue states have an incentive to delay, and throw up roadblock after roadblock after roadblock and just say, hey, there's nothing we can do. I have to interview you, and my next available interview is 6 months from now. So that is totally unacceptable and unconstitutional. And eventually we're going to need likely the Supreme Court to step in and fix this as well. But anyway, bringing you up to speed of what's going on in Honolulu, Hawaii. We'll keep you informed, and hopefully Attorney Alan Beck lets all of us in the Second Amendment community know about his excellent work out there, and hopefully he can do something for those individuals in Hawaii whose rights are being violated apparently by the state and by the city. Okay? All right, folks, hope you learned something here today at the Four Boxes Diner. Please subscribe and share this video widely. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.